not that directional.
It's 9 on page 11 to read as follows. Quote, point 1-1, parenthesis 9, to perform an act of public indecency. Each councilman has on the desk the written provision of the amendment, and in effect what it does is eliminates the offer or agree to perform from that particular section.
Second.
Mr. President.
Mr. Nolan.
Relative to the proposed amendment, I discussed this morning with Mr. Stoll from the City Attorney's Office. With Mr. Huffman from the District Attorney's Office. Mr. Stoffel can make his comments, but since Mr. Huffman isn't here, his input into this was the fact that since our municipal code will provide for a loitering ordinance, he feels that the deletion of, or this amendment would be not detrimental. The only problem is that since the loitering ordinance is in the courts at the present time, in the event the Supreme Court of the State of Colorado determines that particular law is unconstitutional, he feels that at a subsequent date we may want to reconsider this particular provision here. Mr. Stoffel, do you have any further comment?
I would basically agree with that comment. In the discussions in the committee and in the bar committee, the situation that this was designed to deal with are some of the problems in the parks, park restrooms and so forth, which the loitering would to a large extent cover. However, these problems do exist, and an offer, an agreement made to perform them at that location is the situation that this was designed to deal with.
Any other comment? Roll call on the amendment. The amendment will be published only. He recommends that it's all right to go ahead and delete or to pass the amendment.
Mr. Hensel, the District Attorney's Office, the City Attorney's Office both feel that this particular matter is covered in the ordinance insofar as loitering is concerned. We still have the problems, particularly in public buildings and in public parks, and the problem of offering or agreeing to perform these acts of public indecency in public is a problem, but they feel it can be handled under another provision of the code. So they don't see any real problem here unless and until that particular loitering ordinance is declared unconstitutional. If that's the case, I, for one, would like to take another look at this.
Well, you recommending that we vote for or against it?
I believe so, because it's not of any serious consequence at this time.
Oh.
All right, roll call on the amendment.
Blue? Caldwell? Dumana? Hensel? Hook? McIntosh? Nolan?
Aye.
Perry? Roberts? Rosenberg? Wyman? Mr. President?
Aye.
12 ayes, 1 abstention, sir.
The amendment is ordered published.
Mr. President.
The motion to amend carries.
Right.
Yeah. I'd like to make one further amendment, and that is to delete point 1-1 parenthesis 7, and again this is 822 point, that is, and that's to delete that section.
What page are you on?
And if someone will second it, I'll...
Second.
Okay. In effect, what this does is it makes it illegal to do something that really is legal, or what they're trying to do is cover an act that is legal in state statutes and making it illegal to rent a room for such act. And I think that would, in effect, be not proper, at least. The act is, the question by Councilman Rosenberg is what act, and it's easy enough to read, knowing that the same is to be used for or in the aid of sexual intercourse between persons who are not husband and wife, or for or in the aid of deviant sexual intercourse, or advertised in any manner that such person furnishes or is willing to furnish or make available any such facility for such purposes. It's my understanding that there's nothing illegal about any of those acts.
What section are you talking about?
Page 11, 822.1-1, parenthesis 7.
Mr. President,
Councilman Knoll.
Mr. Stoffel, according to this, Mr. Hook is indicating that sexual intercourse between persons who are not husband and wife is no longer an illegal act under the state statute. Is this correct?
That is correct. Yeah, in a private place.
Private place, it's not illegal.
Let's hear from one person at a time, Mr. Hook, please.
Stoffel, would you care to comment on this particular proposal that we delete this section?
Well, this, of course, goes to a financial situation. In other words, where somebody is making a business of this type of activity, and of course this is a policy decision of council. I would point out that one other section that was eliminated from the draft was a section about renting rooms more than one time in a night in a motel or hotel. So at this point, what we could have developed is a situation where there could be establishments established with this purpose in mind, and with advertising renting rooms by the half hour or hour for these purposes. I do not think that because of the acts considered, there are other acts where when you deal with them in a financial matter, a pecuniary matter, that they are illegal, such as gambling, that I can think of right off the top of my head. And where the gambling itself, in a situation of gambling, is not illegal, but professional gambling is illegal. And here we're talking about a situation where a business is being run for the purpose of encouraging these activities. This is a policy question for the council as to whether or not they want this type of activity going on.
Mr. Stoffel, I assume that it is the opinion of the City Attorney's Office, and I seem to recall the District Attorney's Office, that this particular provision, since it is not covered by state statute, does not mean that we are prohibiting something that the state law allows, nor is it just isn't discussed in the state statute. Is that right?
That's correct.
And you feel that this would be a proper purpose or function of the municipal code?
That's correct. Let me check the statute too, just to make sure.
In the code at this time.
If I may stand corrected. Section 40-7-208. Any person who, for pecuniary gain, furnishes or makes available to another person any facility knowing the same is to be used for native sexual intercourse between persons who are not husband and wife. It's the exact wording.
So the only thing that is not in the state statute, in other words, John, as I understand it, based upon that, we could not allow the first portion of this because the state statute prohibits it. But the state statute doesn't speak of, for pecuniary gain,
Yes, it does.
making available a facility for or an aid of a deviant sexual intercourse.
That is also in there.
That's in there also?
That's it. It's exact wording from the state statute.
All right, so then what you're saying is that if we were to take this out, we would be permitting something that state statute prohibits.
It still wouldn't be permitted, but it would not be mentioned in the city code.
Then they'd prosecute under state statute
That's
rather
correct.
than municipal ordinances.
That's correct.
So it isn't that we'd be permitting it, it's just that the ordinances would not cover it. and any prosecution under this would be under state statute.
That's correct. Since we were silent on it, we're not being
Right. But what he's saying is that since the municipal code is silent on this, any prosecutions would be under the state statute. It was my recollection that this was in the state statutes, and that's why we put it in the first place.
Mr. President,
Councilman Roberts.
I'd like a clarification of the point. It was my understanding we were dealing with just the opposite point. And if indeed the fact is that the state statute does not allow these two kinds of acts to occur, then I'd like a restatement of that. Is that what you're saying, Stowe?
No, that's not it, Mr. Roberts. They're saying that what is illegal is for pecuniary gain, to furnish or make available facilities for these purposes.
Mr. Stoffel, I think that question was directed to him.
Yes. CRS 40-7-208 is the statute from which I had thought this was taken from the old ordinance, but it is not. It's taken word for word from the state statute. And also the definition of facility is taken word for word from the state statute, 40-7-208.
Then I'm to understand that this is word for word what the state statute says.
That's correct.
So in our previous discussions and previous public hearings, we agreed that we would stay with the state statute. So I
agree, Mr.
remind
Chairman.
you.
I'd like, and it's a very...
Excuse, if I might point out, in fact, ours did not go quite as far. They have an additional phrase relating to committing or promoting sexual immorality. And we don't title ours the same as that. Theirs is the offense of committing or promoting sexual immorality.
Mr. President, I'm willing to accept the opinion of the city attorney. I would like to ask Mr. Yasui if he would comment on the discussion we had and the opinion as we've just heard it. If you use the mic over the table.
In response to Councilman Roberts' query, I would certainly indicate that the Commission on Community Relations is concerned about discrimination. We are concerned, of course, in regard to good harmony, good order within our community. The specific question that I was asked in regard to this specific provision was whether or not sexual intercourse between persons who are not husband and wife is illegal or is a crime under the statutes of the state of Colorado. Further, I was asked the question whether or not deviant sexual conduct between consenting adults in private would be a crime under the state of laws of the state of Colorado. In discussions with O. Otto Moore, former judge, he indicated that this was not a crime under the laws of the state of Colorado. Now, so far as the point of renting facilities, knowing that such acts occur, I certainly concur with the opinion of the city attorney, but I would also further point out that a landlord who is renting a home or an apartment on a month-to-month basis could certainly be brought in under this ordinance or statute. I think this kind of distinction is a matter that the city council should certainly very carefully look at. I certainly take no legal position in regard to this point, but I do emphasize that there can be injustice, there can be discrimination possible under this particular statute or this particular ordinance.
Thank you.
Mr. Roberts, I would simply like to comment that I know myself that the police department has used this particular apartments or houses which are being rented on month-to-month basis are being used for those purposes, and they have arrested people for just such things. And it's generally done at the behest of some of the neighbors in the community.
I'd like, if I could, clarification. I think I understood an opinion contrary to yours from the city attorney's office that these acts are not against the law under the state statute.
I think the distinction here is that the acts, in other words, sexual intercourse between persons not husband and wife, and deviant sexual intercourse are not under state statute specifically illegal. This ordinance does not deal with the acts. In other words, the persons to whom the room is rented are not necessarily committing a violation. the person making the facility available is the one that's committing the violation.
Well, then it brings us back to the question, if the acts are not against state law, then how would it be against the law for a person to rent a room for that purpose?
This is not necessarily an inconsistency. The acts can be perfectly proper, are perfectly not illegal, and at the same time, the promoting of these activities may be something which the state and the city wishes to make illegal. In other words, the way the state statute is worded, the violation or the offense under the state statute is promoting sexual immorality, which is what they are citing in on in their statute. Same in our ordinance, except that we don't name it. In the state statutes, they name their offenses, and we don't. There's just a section number with a title, and they name their offenses. So,
Mr. President, just one word on this, one word, more than one word, but there is one word. If you look at 822, at the beginning of 822, and you go down from 1-1 to 1-6, there is one word that's common in every part of this, and that's prostitution. Now, when it comes to 1-1 parenthesis 7, it doesn't relate itself, or it doesn't earmark the word prostitution. It's too broad, and it's all-encompassing. And that's the basic argument. You'll notice that in 1-1 parenthesis 5b, it covers, A covers granting and permitting the use of such facility for the purpose of prostitution, or 1-15 parenthesis b, giving a facility and renting it out, etc., for prostitution. And I think that's proper. But when you get down to the other, in effect, you're trying to say a person who rents a place to do a legal act is doing something illegal. And that's the basic argument, I think, that we have to look at.
All right. Further comment?
Mr. President, I would simply like to repeat, if it's in the state statute, it is my opinion that it should be in the municipal code.
All right. Further comment? Mr. Blue.
Councilman Hook, could it be modified so as to include the prostitution factor?
Well, I think it's really covered in the previous 1-15A and 1-15B, because it does specify prostitution. If you want to pinpoint it and say all this is for prostitution, fine. But without that word, it's so broad that you have the reverse situation.
Further comment? Roll call on deleting, what was the section?
822.1-1, print 7.
All right. Roll call.
Blue? Aye. Burke? Caldwell? Aye. Demanna? Aye. Hensel?
No.
Hook? McIntosh? Nolan?
No.
Perry? No. Roberts? Aye. Rosenberg? Aye. Wyman? Aye. Mr. President?
No.
Mr. President, before you make a roll call, I would just like to say, in the event those people were voting for this, what it simply really means is that the police department and the governmental officials will probably continue to enforce this particular law. The only difference is that they're going to do it under state statute, in which the offense is much more serious than it is under municipal ordinance.
All right.
Any of those people who would like to change their vote ought to consider that.
Well, announce the roll. The section is deleted.
Mr. President, excuse me, you will have to change that.
Don't you think we just ought to publish the amendments rather than the whole bill?
That's what I said. Right.
Do we have a motion on the floor?
Move that the amendments be published.
Roll call.
Blue? Burke? Caldwell?
Roll call.
Blue? Burke? Caldwell? Dumana? Hensel? Hook? Rosenberg? Wyman? Mr. President?
Aye.
13 ayes, no
Bill
nays.
passes.
Council Bill 881 authorizes acquisition of property.
Councilman McIntosh.
Second.
Roll call.
Blue? Burke? Caldwell? Dumana? Hensel? Hook? McIntosh? Nolan? Perry? Roberts? No nays, sir.
Council Bill 882 approves plat of Dartmouth Downs.
Councilman Wyman.
Second.
Roll call.
Blue? Burke? Caldwell? Dumana? Hensel? Hook? McIntosh? Nolan?
Mr. President, before I vote, I'd like to ask Mr. Bruce, I know you just got back, but do you know whether or not the survey difficulties on this plat have been...
They have not, and are still a problem, also the wastewater drainage problems. I hope to get them straightened out in a week or two.
Mr. President, I'd like to move that we postpone indefinitely.
No, we'll have to
Council Bill
back up a
882.
little.
State statute and city ordinance. But Bill Bernard was here, and he is appealing that case now to be heard in the Supreme Court in 2 months. He's heard most legal people who know anything about it feel that the Supreme Court will not take it. Yeah, well, that's the danger. As Nolan stated that, well, if the Supreme Court throws it out, then we'll reintroduce something else at the city level. But he was, he was defeated on that. And hopefully, if it comes up again, he'll be defeated on that too. But we, the Gay Coalition, will inform the community as to when it's happening. We'll a watchdog on this body here, and certainly we also like to know the opinion of people about recalling our so-called representative, President Cook.
Yeah, get rid of him.
Yeah, and we like some candidates, or we don't even need a candidate. All we have to do is get rid of them.
How many people here live in Capitol Hill right now?
We'll need volunteers if you can cruise King Soopers and petition at the same time. Capitol Hill every afternoon. Get enough signatures.
Thank you, everybody.
Oh, we got an office now, if anybody ever wants to drop by. 1750 Pennsylvania, number 20.
No, 1460.
14.
Couldn't see the guy.
1450. 1450 Pennsylvania.
Okay.
Come by. Great. Take home a petition. Take home a Gay Coalition.
Anybody is meeting anywhere, discuss it. I got the weekend papers. That's good.